Urge your aye vote.
Thank you for your testimony. Next witness in support of Mr. Wagner's bill.
Thank you. Mira Gerten here on behalf of the California Chamber of Commerce, also in support. We are in support of a lot of these legal reform measures, and in fact, last week we're here on a punitive damage bill as well, because to us these are free economic stimulus bills that the legislature gets to consider at a time when we're really in no position to do anything that costs any more money. And for business, improving the legal climate is a very powerful tool to help them draw businesses here. Punitive damage awards can be volatile, unpredictable, and incredibly large burdens on businesses. Now, when a business commits wrongdoing, we absolutely believe that they need to be punished. We do not seek to protect members who engage in wrongdoing from their just punishment. However, whenever you have discretion, you will have moments of inequities. And we believe the judges are in the best position to prevent those inequities, or at least to minimize them, because they have vast experience and knowledge of similar cases and will have a better sense of what is a fair penalty that fits the crime that has been determined by the jury. And for that reason, we support AB 556. Thank you.
Thank you for your testimony. Next witness in support.
Yes, Dorothy Rothrock, California Manufacturers and Technologies Association, in support.
Thank you. Are the other witnesses here in support of the bill? Are the witnesses here in opposition to the bill? Please begin.
Good morning. John Montevideo, for Consumer Attorneys of California. It's like deja vu all over again. Let me tell you why we are not in support. The 7th Amendment of the Constitution of the United States gives us the right to jury trial. That is also in Article 1, Section 16 of the California Constitution. Trial by jury is an inviolate right and shall be secured to all. And that's what this bill doesn't do. They want to take away from the jury a right that the Constitution gives all of us. That's what it's really about, and it's not needed. It's not broken. Right now, in a jury trial, most of the time, it's a bifurcated trial when it comes to punitive damages. The jury makes a decision as to whether or not the acts of the defendant, in fact, were capricious, in fact, were oppressive, and if so, it goes to a damages phase, where the jury then is given evidence. The jury decides. At that point, a verdict is rendered. The verdict then, as pointed out by the author, does, in fact, have review by the court, the judge. The judge then can do one of two things, and sometimes both. Can vacate the entire award, including the compensatory damages. And then, what ends up happening, the plaintiff at that point has a choice to either retry the case, or the court can do what we call a remittitor, or reduce the amount of damages. And then many times that's exactly what's done, and many times that is what the plaintiff does. Case over. The judge is there, but the jury makes the decision. It's not a decision that is going to be one made in passion. So I know I have a second. I'd like to close one thing. We have to understand here that jury can put a person to death. They have that power and that foresight. They have the foresight to award punitive damages.
Thank you. Next witness in opposition.
Thank you. Scott Bernstein here for the California Employment Lawyers Association. We oppose this bill. People proven by clear and convincing evidence to have engaged in oppression, fraud, and malice are now seeking to have somebody other than the jury that determined that they had engaged in oppression, fraud, or malice determine the amount of the punitive damages. It's obvious why they're doing that. It's because they think that they will save money by doing it. Pure and simple. That's why they're here. There are ample protections already in place. The U.S. Supreme Court has put them there. So this really isn't the huge problem that it is being made out to be. The percentage of cases in which punitive damages are awarded at all is extremely small. And they're only awarded when somebody has been proven by clear and convincing evidence to have done something criminal or despicable. So we see this as yet another soft-on-crime bill designed to make the world better and safer for people who engage in oppression, malice, and fraud. And we urge your no vote.
Thank you for your testimony. Other witnesses in opposition? Seeing none. Questions or comments for Mr. Wagner? Mr. Dickinson, then Mr. Wachowski.
Thank you, Mr. Chairman. I have a question for the author. I gather you don't see any constitutional limitation on removing punitive damages from the purview of the jury and putting them in the hands of the judge.
Of course not, because that isn't what we're doing here. Let me address that point from Mr. Montevideo. If this bill, in fact, took away a Seventh Amendment right, the right to trial by jury, took away any right, I would be joining him in opposing it. But first, there is no right to punitive damages. You have to earn those by establishing with a jury that you are entitled to them. And the current law, as we went through, and Mr. Montevideo agrees, the current law, at the end of the day, does allow the judge to make the final decision. And so we aren't taking away any rights. We are merely streamlining the process. The fact is, with the death penalty, that's really about the only circumstance in the law where we allow the jury to impose the penalty. Otherwise, it's up to the judge, with the exception of the death penalty, because we as a society have rightly made the determination and the value that that's where we want that decision to be made. We also seem to be doing it in terms of maybe the death penalty for some of the corporations that are facing punitive damages. If, in fact, they are found by clear and convincing evidence to have engaged in oppression, malice, they are still going to be held accountable. Nobody is changing that. And so, the argument that this doesn't happen very much, and the argument that we're taking away the right of a jury to find punitive damages is not the case. The jury is always going to make that decision. It's only a question. It's only a question of the dollars that are to be associated.
Let's just focus on that for a second. Your bill would remove from the jury the right to determine the amount of punitive damages, correct?
Correct.
And you don't see any constitutional limitation on that.
Not at all. I think the Gore case makes that clear.
Is there a constitutional right for a jury to determine the amount of compensatory damages?
Is there a constitutional right for the jury to determine the amount of compensatory?
Right. Is that part of the right to jury trial, to have a jury determine the amount of compensatory damages?
In a civil case?
In a civil case.
I think the answer to that is no.
So why don't we take that away from the jury, too, and have a judge just determine compensatory damages? After all, the argument...
I don't like doing that. I trust the juries.
I see. Okay. So that's what it comes down to?
It's imposing punishment, yes. And there's a big difference between compensation and opposing punishment.
Is there?
In my mind, yes, sir.
Well, the argument in favor of the bill by some of your supporters is that the passion and sympathy for plaintiffs affect the determination of the amount of punitive damages. So does a jury just become passionate and sympathetic for a plaintiff after they determine compensatory damages, or does that influence the determination of compensatory damages as well?
No, Mr. Dickinson. The determination of compensatory damages is governed by a whole series of evidence code provisions and the proof at trial as to the actual damage, the lost wages, the damage to the consumer. You name it. It depends on the particular circumstance.
So
that's all a matter of evidence.
That's strictly arithmetic. Never subject to passion or sympathy for one party or the other.
Oh, there's no question we have runaway juries in lots of different areas, but we can't fix everything with one bill.
Well, that may be a total defense. I would grant you that. But aren't there restrictions, limitations, guidance, and direction to juries on the determination of punitive damages, too?
Yes, there are. There absolutely are.
So why then do juries become incapable of determining the amount of damages that are to be imposed for exemplary purposes, but they're perfectly competent and capable of figuring out what compensatory damages are?
That is a fair question. And I think that if we hadn't recognized as a legislature and as a bar that juries in fact did that, we wouldn't provide the stopgap that's there for the judge to reduce the amount, engage in negotiations, or have an appeal. But we recognize that that is a possibility out there, and so we provide these safety valves.
But added or remitted or don't apply just to punitive damages. They can apply to compensatory damages too.
Okay.
So the judge has the same authority with respect to compensatory damage determinations as to punitive damage determinations. So how is that a distinction?
Because in these circumstances, what we're talking about here is punishment. When it's a compensatory scheme, we're not talking about punishing a defendant. And punishment is different.
So again, we come back to juries. You're competent to determine the amount of compensation, but not to determine the amount of punishment. That takes a judge.
In practice, it is taking judges. In reality, it's taking judges. And what we're trying to do is streamline the process, provide some more certainty for the business community, and frankly, I think aligning our civil punitive damages law with our criminal law, where again, we allow the judge, you have a right to the jury to determine guilt or innocence, but you allow the judge to impose the punishment with that one exception that we made as societal.
And for me, with all due respect, the flaw is here that you're proposing that we trust juries to follow judges' instructions and to otherwise follow the law in making determinations in some aspects of determining damages, but not in others. And I don't know what makes a jury become one that's competent to do one thing and incompetent to do the next.
We're not saying the jury is incompetent to do this. What we are saying
incapable,
is that the
incompetent,
jury,
unable. You choose your term.
That the jury is not the proper place for the punishment decision to be made. They'll decide up or down on guilt. They'll decide up or down on oppression, fraud, or malice. But the punishment, 5 years in prison for a break-in, 10 years in prison for some fraud or embezzlement, the amount of punitive damages, the punishment should be left with the judge because that's where it is already under existing law, as both of the witnesses have acknowledged.
Thank you, Mr. Dickinson. Mr. Wagner, there's often a critique these days that there aren't enough lawyers in the legislature. You will not hear that critique expressed in this room today, I'm for sure. Mr. Wachowski.
I applaud the author's desire to streamline the process and to bring quick resolution.
That's my closing.
And what I'm surprised with, if you suggest that we move to the judges to make an actual finding of fraud, an actual finding of malice, an actual finding of oppression?
I'm not suggesting that, no. No, the jury remains the determining agent whether there is, in fact, punishment to be applied, whether there was fraud, oppression, malice, by a clear and convincing standard. I'm not changing any of that. Okay. That remains the province of the jury.
Why would you not change the level of standard to a preponderance, since now you're going to put an overlay of an impassionate judge to determine what the right level of punishment would be? Why wouldn't you give the jury the tools just by preponderance of evidence? Get rid of this Lockyer law that raised the standard and simply allow the jurors just to find a low-level preponderance, and then that wise judge to set the right level of punishment for that defendant.
Maybe we'll be back here next year with that.
Because it seems if you don't do them both, then if you want to lower the standard of finding for this jury who may lose their way in the courtroom by some lawyers, then you would have that judge as your backstop. Is what I think you're suggesting in the bill, that the judge would be there to find the right amount of punishment, the dollar level that would be, and that may be fair. That may be a way to fix the bill.
Mr. Wachowski, let me suggest that what we have in the punitive damages law right now is a heightened standard, but it is not the standard that we impose in the criminal laws, which is clear, which is beyond preponderance of the doubt. We have a clear and convincing standard. That is because we recognize, again, societally, and it's developed in the common law over the last 250 or so years, that for punishment, we want something more than just a slight a weighing and a slight preponderance. For punishment, we want a heightened standard. again, societally, we are not going all the way to beyond a reasonable doubt, and nobody is advocating that. But by the same token, it wouldn't be appropriate to lower it to the same threshold that you would otherwise have. But that is a completely separate thing than the question of, once punishment is determined to be appropriate, who applies it?
No, but you have to find actual oppression. There has to be a finding, whatever that level that we're the policymakers, we could change that level, because it seems to me that you're saying that there's harm out there in the community for the defendants, and that you need the judge to actually to correctly set that monetary level. So why not give the jurors they still would have to make a finding. It still has to be 51% of the balance that there was actual fraud and this wrongdoing for punishment, and then the judge could fix it on the dollar amount.
I don't do that because, again, as a society and over the course of the history of the development of our common law, we have decided that for the purposes of imposing punishment, we want something more than a mere 51%. We want something more than a balance and just see what tips one way or the other. That's fine in a civil case for contracts, disputes, and other types of civil actions. It is not enough if you're going to impose punishment. And what we're talking about here is not changing whether or when or if we impose punishment. What we're talking here about is merely aligning the punitive damages law with the other punitive statutes or provisions of our law that allows for that decision to be made ultimately by the judge.
Okay. Thank you, Mr. Wachowski. Mr. Monning.
Thank you, Mr. Chair. Mr. Wagner, thank you for at least fueling a very informative conversation. I do understand your interest as opposed to try to streamline a system and remove what appears to be maybe redundancy. Mr. Nastandi earlier was proposing a reform that I think would have extended the process and cut against the interest of class members. So I think there's some fundamental differences. Can you tell me, has any other state followed this this practice?
I believe so, but let me turn that over to the experts.
I actually haven't seen them impose this particular reform. I've just seen the other types where they put caps in place, or they changed the standard, or they.
What state did that?
Let me just check. The caps.
Yes.
I'm sorry, I don't have the list
okay,
with me.
If it's not right at your fingertips. I understood somebody alluded to the state of Kansas having followed this practice. But if that's not ringing a bell.
I do not know that to be true.
I do believe from the analysis from committee staff at page 5, it does appear that Kansas is the one state that goes to the extent this bill does, according to the analysis.
Great. Well,
anyway,
I mean,
so yes.
that answers my question. I mean, I don't know too much about Kansas other than it's the land of Oz. But beyond that distinction, in my experience, punitive damages, first and foremost, are very rare. I think even though you have in the current system judicial oversight, and as witnesses describe the options available to a judge, I believe there's a utility to the jury that has heard the evidence, heard witnesses, received jury instructions delivered by a judge as to the purpose of punitive damages and what their authority is. Let's remember, punitive damages are rare and they are imposed as punishment. Derived punitive is to punish, and it's based often on the assets and resources of the defendant so that it serves to punish them, so that it's not a de minimis once you've reached this very high standard. The fact that the judge can review not only the verdict but the imposition of punitive damages, the fact that 12 members of a jury have to, in their deliberations, come to some consensus about those punitive damages, having heard the testimony, to me that provides something that informs the judge that it took 12 people reaching consensus that this is an appropriate level of punishment. Even though the judge ultimately could reduce that or even vacate it, I would guess in most cases it does serve as a standard from which the judge reacts or to which the judge reacts. So if we eliminate that part of the process, we're eliminating what I think is a very vital and constitutionally protected and contemplated role of the jury, not just in finding liability, but based on what they've heard, going through a deliberative process, not just of one, but a deliberative process of 12 or of 9 to determine this is what we will recommend to the court as an appropriate level of punishment based on the instructions received, based on the evidence we heard. So I'm not really formulating a question here. I am offering, with all due respect, why I won't be able to support this bill. But thank you for your effort.
Thank you, Mr. Monty. Any other questions or comments for our author? Seeing none, Mr. Wagner, wish to close.
Thank you, Mr. Chairman. We have gone through this exhaustively. I repeat that the concerns that we've heard from the consumer attorneys perhaps are a bit excessive. I think they have been answered. I think that we are doing no great injustice to the common law. In fact, we are streamlining the process and conforming our punitive damages law to our criminal law. For that reason, I urge an aye vote.
Thank you very much. Is there a motion on the bill? The bill's been moved. The bill's been seconded. Call the roll, please.
Fear?
No.
Fear, no. Wagner?
Aye.
Wagner, aye. Atkins?
No.
Atkins, no. Dickinson?
No.
Dickinson, no. Silva? Silva, aye. Huber?
No.
Huber, no. Huffman? Jones? Yes. Jones, aye. Monning?
No.
Monning, no. Wachowski?
No.
Wachowski, no.
That bill has 3 votes. It requires 3 more. Now we'll proceed to our last item on the agenda. That is AB 934, item number 9. That's my bill. Mr. Wagner? Mr. Wagner, if you would assume the chairmanship as I proceed to handle AB 934.
We are on item 9, which is Assembly Bill 934, introduced by Assembly Member Fuhr. And, Mr. Chairman, you may proceed.
Thank you very much, Mr. Chair. So at the beginning, I'd like to be clear that I am taking as author's amendments the analysis, including the provision that says that the bill will not prevent anyone from invoking the litigation privilege in the event that there is a defamation claim brought. And that leads me to provide a little context for the bill itself. Let's discuss the litigation privilege. That privilege is intended to do something very important in court proceedings. It's intended to say to a litigant, you can pretty much say whatever you need to say, whatever you feel you need to say in a court proceeding without fear of being sued for defamation. It's a good rule. It's an important rule. But that rule was really turned on its head in a couple recent decisions, one of the California Supreme Court and one of a court of appeal, that for the first time, a couple of years ago, said that the privilege can be used to dismiss a tenant's action for unlawful and retaliatory eviction. First time. All of a sudden, after years of the rule being that a tenant could bring those claims. Those actions have nothing to do with defamation, nothing to do with the underlying purpose of the litigation privilege. They have to do with the conduct of suing, of filing a notice, and of bringing a lawsuit. That's all. The court, astonishingly to me, in Action Apartments, even said this protects even unlawful detainer actions brought maliciously. Think about that for a second. You can bring a maliciously intended action to try to get someone out of her apartment at this moment, in this recession, get her out maliciously, and the action is completely protected from a tenant's effort to claim that's an unlawful eviction in a separate action. It's an extraordinary rule, and it needs to change. And that's the purpose of this bill today. This bill preserves a tenant's right to bring a meritorious claim for a wrongful eviction that's attempted, whether that action is based on local ordinance or state or common law. I want to underscore that it exempts from such matters the ability of no tenant can claim defamation as the bill has been amended. The litigation privilege was designed to assure that one have the greatest latitude possible in a court proceeding. Ironically, the unprecedented expansion of the litigation privilege in these two decisions would protect even unlawful conduct and essentially bar from court a tenant's claim, an affirmative claim for a wrongful eviction. The opposite of what the litigation privilege is about. So let's cut to the chase here. Let's talk about what opponents will claim. Opponents will claim that the bill is going to subject landlords to frivolous litigation. They bear a very high burden here because they have to explain why decades of practice before Action Apartments didn't create that flood of frivolous litigation, and all of a sudden this bill, which simply seeks to restore the status quo before Action Apartments, will have that effect. There's not a scintilla of evidence, no data at all that any opponent has presented thus far to suggest that that's even close to true. What you will hear, however, and what the letters of support have revealed, is that the Action Apartment case and Park Lane have done something else. They have protected landlords who have brought malicious claims, wrongfully attempting to evict people. They protected them even from public law agencies attempting to enforce what they believe to be our important local ordinances. By the way, this bill, I think, will have another effect that addresses a concern that has been raised by opponents. Opponents say, this is going to deter people from trying to work things out, landlords and tenants. I practiced in this area for a long time. I'm a big supporter of trying to work things out informally if it can be done. Nothing about this bill makes it less likely that landlords and tenants will work things out than they attempted to do until 2007. Now, another claim that will be raised by opponents is that the bill takes away a traditional right that landlords have had. Let's be real. The tradition was the litigation privilege did not bar tenants from bringing actions for wrongful eviction. The anomaly is the past couple years after Action Apartment and Park Lane. Opponents claim, too, that tenants have all kinds of opportunities here to claim the action to evict them is wrongful. They can defend themselves in the unlawful detainer by raising that as a defense. Very limited discovery in that context, by the way, as people here know, just a few days' worth of discovery. But the point is that where a landlord only issues, say, a notice to evict, which we all have heard in our own districts in the wake of the foreclosure crisis is leading tenants to leave their apartments without even having a matter litigated, those notices don't give anybody a right to defend anything. People just leave. Not a good thing. This is an affordable housing bill as well, by the way, because let's first say, I will stipulate to the fact that this bill, like so many other bills that we pass out of this legislature and get signed into law, is designed to address a small minority of people, a small minority of landlords who do the wrong thing. Because let's agree that the vast majority of landlords do not attempt to do the wrong thing. But when a landlord does seek maliciously to get someone out, it may be in a situation, like in many jurisdictions around our state, where there is what's called vacancy decontrol. That rule, as you know, says that the rate that a tenant pays is set, there's a CPI adjustment, but once that tenant's gone, the rate can go to wherever the landlord wants it to go. There is an incentive in such cases, and we have seen, as you will hear, evidence that landlords have sought to take advantage of that incentive in a way that none of us would think is fair. So in sum, all the bill is doing is to restore the status quo before Action Apartments in 2007. A status quo that, as far as I know, led no legislator to come to this House and say, we have to curtail frivolous actions by tenants seeking to waste everybody's time and needlessly expend money by trying to claim their actions were wrongful, the action of the landlords was wrongful. I was here in 2007 and 6. No one brought such claims. So why this bill suddenly creates that opportunity, I don't get. Fairness, however, I do, and I urge an aye vote. Now I have two witnesses in support.
Thank you, Mr. Fuhr, and if we could hear from your witnesses, please.
Thank you, Mr. Vice Chair and committee members. Good morning. My name is Dean Preston. I'm the Executive Director of Tenants Together, California's statewide organization for renters' rights, and thank you very much for the opportunity to address you today on AB 934. This is an important bill to ensure that tenants have access to the courts when they are subjected to illegal eviction activity. As Chair Fuhrer referenced, prior to the California Supreme Court's decision in the Action Apartments case, landlords who illegally evicted their tenants could be held accountable in court. Indeed, for decades, that has been the state of the law, and California courts repeatedly upheld lawsuits based on illegal eviction conduct. Everything changed in 2007 when the Supreme Court expanded the litigation privilege into the landlord-tenant arena to protect landlords from liability for illegal eviction activity. And subsequent appellate decisions, particularly the Feldman versus 1100 Park Lane case, has made the situation worse, further extending the privilege in the landlord-tenant context. In so doing, the courts have violated decades of precedent and severely undermined tenant protections. The judicial expansion of the privilege has been devastating. Tenants are effectively barred from seeking redress through the courts, and bad actors are noticeably emboldened to engage in further illegal eviction activity. In jurisdictions with rent control, like Oakland, East Palo Alto, Los Angeles, some unscrupulous landlords use bogus eviction notices with impunity to push long-term low-rent tenants out of their home and take advantage of the vacancy control that Chair Fuhrer referenced. Outside of the rent control jurisdictions, the problem is most pronounced in foreclosed properties, in renter-occupied foreclosed properties, where banks and private investors acquiring these properties after foreclosure routinely serve meritless notices to quit and unlawful detainer cases. Under Action Apartments, these tenants have no meaningful remedy. This bill would restore protections for aggrieved tenants without imposing any new obligations on landlords. We urge your support.
Thank you, Mr. Preston. Next witness in support.
Good morning, Mr. Vice Chair. Is this on? Okay.
No. Leave it alone.
Okay. Good morning, Mr. Vice Chair and members of the committee. Thank you for the opportunity to speak to you today about this important bill. My name is Julia Figuera McDonough. I'm a Deputy City Attorney with the City Attorney's Office of Los Angeles, and I'm here to express my office's strong support for this bill. As has been noted, the current interpretation of litigation privilege prevents tenants from taking legal action to combat unlawful eviction actions and notices. As a result, my office is faced with an increased responsibility to protect these tenants' rights, but we also find our hands tied by the existing state of the law. Tenants are therefore doubly victimized, subjected to bogus eviction notices and actions, and left without recourse to correct the injustice. The scenario my office most often sees has been referenced. It follows a particular pattern that began to emerge more clearly in the wake of the foreclosure crisis. New property owners issue notices to quit, falsely informing tenants that they are required to vacate their units because the building has been foreclosed upon. Although foreclosure is not among the permissible bases for eviction under the Los Angeles Rent Stabilization Ordinance, many tenants are unaware of their rights or of the existence of legal services to assist them in enforcing those rights. As a result, many tenants abandon their units, mistakenly believing that they are required to do so. As has been noted, there is ample incentive for this unlawful practice in LA because it is a rent-controlled jurisdiction where the departure of a tenant deregulates the unit and allows it to be rented at market rate. To make matters worse, most of these cases are concentrated in low-income neighborhoods where tenants are even less likely to be aware of their rights and are often already living on the margins of poverty, and the consequences of being forced to vacate their homes can be disastrous. The litigation privilege was originally intended to guarantee access to the courts. Perversely, as the Chair has noted, the result of its recent judicial expansion has been just the opposite. There is nothing in AB 934 that would create any new obligations under the law. And there is nothing in the bill that would be an incentive for frivolous lawsuits by tenants or by law enforcement. Rather, the bill would simply restore Civil Code 47B to its original purpose. I urge you to pass AB 934. Law-abiding landlords have nothing to fear by its passage, and vulnerable tenants stand to gain much-needed protection from unscrupulous and illegal eviction activity. Thank you.
Thank you, Ms. Dunham. Are there any other witnesses in support of the bill?
Christine Menahan, Western Center on Law and Poverty. My two colleagues have very adequately covered all of the reasons that Western Center judges this an important bill.
So you're in support?
We urge your aye vote.
Thank you very much. Any other witnesses in support?
Brian Augusta on behalf of the California Rural Legal Assistance Foundation in strong support.
Thank you.
Denise McGranahan from the Legal Aid Foundation of Los Angeles. We strongly support this bill.
Thank you.
Julius Thompson from Bates-Sedek Legal Services. We strongly support this bill.
Thank you very much. Are there any other witnesses in support? All right, let me turn to witnesses in opposition. Are there witnesses in opposition? Mr. Shannon?
Yes. Mr. Chairman and members, Tim Shannon representing the California Apartment Association. The hour is late. We've had a lot of discussion today. This is a very complicated subject matter. The two cases that are mentioned in the committee analysis involved two really different types of action, one being an action regarding the litigation privilege and the other anti-SLAPP lawsuits. And those, although similar, are actually very different causes of action. And I just would like to point out that the history of the litigation privilege goes way, way back. It has been supported by the courts consistently. There are very few exceptions to the litigation privilege. The purpose of the privilege, as has been mentioned in the analysis, is to provide litigants and witnesses utmost access to the courts without fear of subsequent harassing litigation. I would like to point out that the case that's been cited, the Supreme Court case, really had to do not with a state statute, but it had to do with an ordinance. It was an ordinance that was passed that carved out its own exception to the litigation privilege. And that's why the Supreme Court in a 5-2 decision basically said that that ordinance was preempted. I think one of the policy implications that you need to consider is why access to the courts is so important. This is the way of conserving not only judicial resources, but also preventing plaintiffs from being subjected to endless litigation. I'd like to quote just briefly, if I might, from the Supreme Court decision. This and other courts have emphasized the importance of the litigation privilege as absolute protection of access to the courts, while recognizing that this absolute protection has its costs. It's desirable to create an absolute privilege not because we desire to protect the shady practitioner, but because we do not want the honest one to have to be concerned with subsequent derivative actions. And that's really the heart of this. Let's look at the practical impact of this bill. I'm going to wrap up very shortly. The practical impact, and this is, despite what the committee analysis says that there won't be frivolous lawsuits and there won't be a deterrent effect, there will be. You just had a very long discussion about punitive damages. There is nothing to prevent a tenant to not only sue in a derivative action, but also act for punitive damages. This will have a chilling effect on apartment owners who are many times vindicating the rights not only of themselves, but of the other tenants of the apartment complex.
Very well. Thank you, Mr. Shannon. Other witnesses in opposition?
Thank you, Mr. Chair, members. Ron Kingston, representing the San Francisco Association of Realtors and the Apartment Association, California Southern Cities. There are several statements that have been made arguing in favor of this bill, and there are some very important responses that I would like to provide. First, it's argued that tenants have no meaningful remedy to illegal eviction actions. We're here to tell you that we're just not in concurrence with that at all. There is plenty of defense. If there is an argument of an illegal eviction due to foreclosure or any other, there is more than adequate remedy. Second, it is argued that it is important to invalidate the cases, as been noted in the bill on the last page, seeking to invalidate the two cases which Mr. Fuhr has noted in his presentation. If the problem is malicious prosecution, then let's drill down, let's deal with that issue as opposed to throwing the baby out with the bathwater. It's been argued that landlords, or should I say, better yet, tenants are barred from seeking redress. That's a constitutional right. This bill nor the courts can interrupt that absolute right. We respectfully disagree. It's been argued that decades of law have been, there was nothing wrong with those decades of law, yet during the interceding time, the legislature and the courts have interpreted the law, expanded the law. That's what we're all about. Now, once again, what we're here to do is to discuss the appropriate remedies instead of this massive expansion, as Mr. Fuhr and the proponents argue. Last, because I'm being respectful of the time and there are other opponents to this, the measure seeks to strongly suggest local governments have rights dealing with an expanding or adopting ordinance with regard to termination of tenancy, eviction, and harassment. This bill, it doesn't even deal with the issue. Thank you, Mr. Chair. It doesn't even deal with this. That is inappropriate with regard to and seeking the remedies that the proponents suggest. We respectfully request a no vote.
Thank you, Mr. Kingston. Other witnesses in opposition?
Mr. Chairman, members, John Smock, representing the Apartment Association of Orange County. We too are in opposition.
Thank
you,
Mr. Smock. I believe we've registered the opposition, and I appreciate hearing from you. Any other witnesses in opposition?
Mr. Chairman, Dave Milton with the California Association of Realtors, and we are opposed to the bill as it's currently in print.
Thank you.
Mr. Vice Chair and Chair and members, Steve Carlson for the Apartment Association of Greater Los Angeles, San Diego County Apartment Association, and the Santa Barbara Rental Property Association in opposition.
Mr. Chair and members, Matthew Harg with the California Business Properties Association here in opposition to the bill. We are concerned about its commercial applicability.
Right. You're not, got it. Thank you.
Civil Justice Association in opposition.
Okay. And we do have a two-witness rule that the chairman has enforced, and I feel I should do the same as well. But the opposition is registered. Any further witnesses in opposition? Questions from any of my colleagues? Ms. Huber.
Thank you, Chair. I have to say that I've litigated the litigation privilege before, and I believe in the litigation privilege as a way to prevent lawsuits about lawsuits. And if it wasn't for you agreeing to take some amendments, I would not be supporting this bill. But I do think that there's a way to amend the bill that will address some of the concerns of the opposition and pare back the ruling of the court without eliminating it completely. So I applaud your taking the amendments on defamation suits, but I think that I'm willing to give you the vote today to get it out of committee, but I think that we have more work to do to make sure that we're not relitigating the underlying lawsuit, not just on the defamation, but it's one thing to say the conclusion of, well, you evicted me, and therefore I have a claim for wrongful eviction for a host of policy reasons on why that eviction was unlawful, as opposed to you evicted me and everything that you said within that lawsuit, the underlying eviction is the basis of my claim. And that's where I want to make sure that we're capturing the spirit of the litigation privilege and not just I'm not sure I'm comfortable with just calling out defamation cases, but making it a little bit broader. But I appreciate your willingness to amend it to make sure that the litigation privilege does survive. So thank you.
Thank you, Ms. Huber.
Further questions or comments? Mr. Dickens.
The conundrum, it seems to me, that we're presented with here is that you're dealing with notices or with an unlawful detainer, which is a summary action. If we were dealing with litigation in the normal world, such that could ever be called normal, you could raise affirmative defenses or file a cross-complaint and have an adequate time to litigate all these questions of state law, local ordinances, whatever they might be. And the problem here is that in a case where there's just notices issued, there is no litigation. So if you're barred from bringing litigation, I don't know how you present the question to an arbiter. And in the case of an unlawful detainer action, if it's a five-day proceeding before you respond, and a summary proceeding at that once it's heard, I don't know how you raise offenses effectively without the chance to develop evidence and find witnesses and make presentations. So there does need to be something here. I agree with Ms. Huber about whether or not, in principle, there's a way to reconcile all this that allows certainty and doesn't cause increased litigation. But it seems to me, for the moment, returning to what the state of the law was for generations is not an unreasonable thing to do while we search for that sweet spot that may exist as an alternative.
Thank you. Further questions or comments? If I may briefly, a question of the author and then one perhaps of either Mr. Shannon or Kingston on behalf of the landlords. First, I want to echo what Ms. Huber said. The amendment is... Without it, I think I'd have a problem. With it, I think we're a lot closer. Let me ask the scope of the amendment. The language I have says that an allegation or averment contained in a pleading or affidavit shall be privileged, and typically the litigation privilege applies also to statements that are leading up to such pleadings, allegations or averments, and I guess I'm asking the scope of the amendment. Must it actually be contained in a pleading or affidavit, or might there be some pre-litigation comments that would fall within the scope of the litigation privilege as amended?
I am very wary extemporaneously to identify what pre-litigation comment might fall within the ambit of what's intended here, because I'm skeptical of pre-litigation comments being included within this amendment. But let me do this. I think what I'd like to do for purposes of today is to reinforce my commitment to the amendment that is stated here, and I'd be delighted to sit down with you and talk further about what exactly it is that you have in mind and see whether it can be contemplated. But today I don't want to, as I'm standing here on the fly, make a commitment to anything.
No, I appreciate that, and I guess I'm not actually asking for specific language. It's just, the litigation privilege is broader than just a statement in litigation, which was recognized in Action Apartments, and I mean that's the law, I guess. My question is, do you intend to follow that law, or are you looking to, with your amendment, to just be very specific that the exception only applies where the statement is in a pleading or affidavit?
I have been intending the latter. Okay. I am open to a discussion of the former, because I want to flesh that out more. But what I've been trying to do is come as close as I can to saying, look, here's what the law was always previously. There was no great problem with the law previously. Let's get back to where that was, because there is a problem now. But again, I'm very receptive to further conversations. There have been many members who have alluded to the potential for further fleshing out detail here, and I'm, as you know, extremely receptive to that conversation.
And I appreciate that. And my question for the representatives of the apartment folks would be, have you seen the amendment? What's your take on the amendment? Does it fix the bill?
Well, it moves in the right direction, but clearly, and this is the interesting part about the litigation privilege, it has expanded. It originally only applied to defamation and statements, but the courts realized that once again, the utmost access to the courts is so important that it needed to be expanded to other things. Under this bill, even with the amendment, the mere filing of an unlawful detainer action can be claimed to be malicious. And remember, you never get past summary judgment then, because that's a question of fact. And so you have a situation where a good guy landlord who's trying to have some quiet enjoyment in the apartments is not going to file an unlawful detainer because he could be sued. So it doesn't go far enough, unfortunately.
And may I say that potential existed before 2007. And again, there is a burden.
It did not. It did
Why?
not.
Wait, hang on, Mr. Shannon. No, we're not going to have that debate here. Let me ask, why does the traditional remedies of a malicious prosecution action and abusive process, the SLAPP statutes, how do all those play in, and why are those
No,
not?
it's not. Malicious prosecution requires that there is an underlying action, that you win the underlying action, and then you move forward. If you file, as Mr. Dickinson said, if you file a notice that says get out, there's no underlying action, there's no adjudication, there's no remedy. You're done. And that's one of the issues that's been raised here by the proponents of the legislation, particularly in this world that we're all trying to navigate in the foreclosure crisis, which the shrapnel has flown not only to single-family homeowners, but it also addresses tenants in each of our districts, some of whom are in precisely the situation that we're talking about here.
If I might.
Thank you.
Sorry.
And let me be clear. It has historically been the case that the filing of an action or the filing of a notice could be the predicate for an action in wrongful eviction. That always has been true. And there has not been, again, listen carefully to the opponents. Have you heard one of them say, a study from 1998 showed that there's this prevalence of wrongful eviction actions that have no basis at all, and it's clogging up the courts, and it's inhibiting mom-and-pop landlords from getting their rightful return on their investments? Not a word to that effect, because there is no data supporting that contention.
All right.
Steve Carlton. Well, just to restate it, wrongful eviction is a state statute. The Supreme Court case was aimed at a city ordinance. That's the big distinction, and that's the difference. A state statute can be enforced, not a local ordinance.
And, Mr. Chair, Park Lane extended the Action Apartments rationale to state statutes. Mm-hmm. And by the way, all of us in this room at one point or another have invoked the important principle of local control. And Action Apartments, it's true. And Action Apartments eviscerates the opportunity of a jurisdiction to say, here is what we define as a wrongful practice when it comes to the relationship between landlord and tenant.
It is getting late. Mr. Carlton, briefly,
Mr. Chair,
sir.
Members, I'd like to point out that the exceptions to the litigation privilege are very narrow and virtually all sound in fraud. A finding that an illegal act had a case, you don't tell somebody that there's an insurance policy, you don't tell them there's another case pending in a lease pendants. This takes it way beyond that. This bill doesn't say the basis upon which you lose the privilege is that you have engaged in fraud, that you are totally baseless in whatever it is that you said. It does not say that. It says that anything that you say in the course of this action can hold you liable for an action brought back against you. And that is the concern. And that is what the local ordinance did in Santa Monica that was the subject of the Action Apartment case.
Thank you. Further questions or comments? Seeing none, Mr. Fury, you may close, sir.
Yeah, I just very briefly. I have said on multiple occasions this morning that we ought, to the extent we can, be driven by data. And there isn't any, including for the concern expressed by Mr. Carlson at the conclusion of the opponent's testimony just now. No data that says before Action Apartments there was a problem that now they are claiming will exist if this bill passes. All the bill seeks to do is to clarify the law with regard to what everybody thought was the case before Action Apartments. So data, evidence, none. I think we have litigated this bill enough this morning. Let me conclude by just saying this much. We ought to give, among others, our public law enforcement agencies, one of whom is here today flying up on their own nickel to be sure that this legislature hears from it, the opportunity to enforce existing state as well as local ordinances designed in this post-foreclosure crisis recessionary moment to assure that every one of our tenants in all our districts has its rights protected in a way that imposes no obligation on any landlord that didn't already exist before Action Apartments and takes nothing away from any apartment owner that didn't already exist before Action Apartments. I urge an aye vote.
Thank you, sir. There's a motion. Is there a second?
Second.
Mr. Monning and Mr. Wachowski, and we'll call the roll.
Fear.
Aye.
Fear, aye. Wagner.
Aye.
Wagner, aye. Atkins. Dickinson. Aye. Dickinson, aye. Silva. Huber.
Aye.
Huber, aye. Huffman. Aye. Huffman, aye. Jones. Monning.
Aye.
Monning, aye. Wachowski.
Aye.
Wachowski, aye.
That matter is out. Thank you, Mr. Fuhr.
Thank you, Mr. Chair.
And okay. And I will pass the gavel back. Unfortunately, I don't get to bang it. As amended.
Yes. So, Mr. Weiner, thank you very much for chairing on that matter. Let's proceed to go to matters on call. The first such matter is item 1, AB 22 by Mr. Mendoza. The vote is currently 4-3. Chair voting aye. Call the roll.
Dickinson? Aye. Dickinson, aye. Huber?
No.
Huber, no. Huffman?
Aye.
Huffman, aye.
That bill has 6 votes and is out. Item number 3, AB 271 by Mr. Nastandi. The vote is currently 3-6. Chair voting no. Call the roll, please.
Huffman? Huffman, no.
Okay, that bill fails. Item number 4, AB 312 by Ms. Lowenthal, excuse me. Ms. Lowenthal has a vote of 4-3. Chair voting aye. Call the roll, please.
Huber?
Aye.
Huber, aye. Huffman? Aye. Huffman, aye. Monning?
Aye.
Monning, aye.
That bill has 7 votes and is out. Item number 5, AB 433, also by Ms. Lowenthal. The vote is 5-3. Chair voting aye. Call the roll, please.
Huber?
Aye.
Huber, aye. Huffman? Huffman, aye.
That bill has 7 votes and is out. And the remaining matter is AB 556, which is item 6. Mr. Wagner, the vote is 3-6. Chair voting no. Call the roll, please.
Huffman? Huffman, no.
That bill fails. Seeing no further business before our committee, with a lot of gratitude to the members of the committee, we're adjourned.